Good morning and welcome to the Senior Hour, which is sponsored by Comfort Keepers in Home Care and Advanced Audiology. I'm Barbara Cochran with my co-host,
Dr. Jean Dorio,
on your hometown station, AM 1220 KHTS. And before we introduce our new host, my co-host has a couple of announcements.
Oh yeah, you and I have been greatly involved in the Senior Center, and they have a lot of activities going on there. So I just want to point out to our listening audience, seniors and non-seniors, we do have bingo at the Senior Center now, and it's been going on. It's very successful, and even for some financially rewarding to a certain degree. But it's a lot of fun, and it's on the first and third Thursdays and the fourth Saturdays of the month. This in April, it'll be April 6th, April 20th, and April 22nd, which is a Saturday. And on the Thursdays, it's 2 o'clock to 5 o'clock. Doors open at 1:30, and on Saturdays it's 1 o'clock. But it's at the Senior Center, and we have door prizes and a lot of great prizes, cash prizes as well. And it's a lot of fun for our seniors to be there and be involved in our Senior Center, because it's just a different way of making your mind work and getting your body out of your house.
That's right.
Additionally, on March the 30th, next Thursday, we have a concert and a simultaneous art exhibit. And the concert is by the Silvertone Singers, and it's called Man Oh Man, and it's a concert of songs based on men's names.
How interesting.
Like Alexander's Ragtime Band, Bill Bailey, Message to Michael. Pretty cool, huh?
That's very nice.
And there'll be an art exhibit as well. The concert starts at 2:45 to 4:30, and the ongoing art exhibit are pieces that have been done by our seniors over at the Senior Center. And I think, the public would be really surprised about how artistic and talented
yes.
some of our seniors are. So come on out, not only to bingo, but also to the concert and art exhibit next Thursday, because that'll be a lot of fun for our seniors to get out.
Terrific. I agree with you. And now this is going to be something very interesting. I'm introducing Randall Kaiden. Randall Kaiden. He is an elder law attorney, and he's going to be our host for today, which is quite interesting.
Yeah, I thought I'd flip it around today. I've been here with you all for about 6 months and talking about estate planning and elder law, and I thought it'd be interesting to ask you questions and see what your opinions are on certain subjects.
Put us on the spot, huh?
Put you on the spot, right, exactly.
Sounds like a winner. Well, let's go for it.
Yeah, we'll see how it goes.
Yes.
So one of the questions that I get asked almost every day, and I'll put it to you both, is when people create an estate plan and ancillary documents, they want to know, or they have somebody in mind who they want to put in control of their financial affairs, in their trust, in their financial power of attorney, as well as their agents for healthcare directives. But specifically for this question, in case they become incapacitated or after they're gone, and I'm curious, who would you think that most people would want to put in control, and or maybe who would you put in control, and why?
Ladies first.
Well, I probably would put one of my children in control.
Okay.
And what we have done, Russ and I have put our son-in-law in control, our daughter's husband.
Okay. So what I would ask about that is, first of all, how many children do you have?
I have 2.
Okay. And how do you decide which child to put in control? Because, I get a lot of parents that say to me, I feel badly if I name one child over another child, because I think that, that other child might be kind of insulted. I, of course, always say, the other child is the lucky one because they got off without having to do all the work. The one who you name to put in control has to do a lot of work, and they're usually not aware of it at the beginning, but they are as they get into this process. But it's an interesting response when I get that. And then you said the second person, your second successor trustee, that is your son-in-law, and Generally, we don't recommend that because, well, frankly, unfortunately, the divorce ratio in California is so high that we're just worried that, if somebody gets divorced and then they're in control of decision making, well, that's a problem. Potentially
It's
a huge problem.
because, so just so our listeners understand, it's not a problem with that person, individual person. It's a problem with the legal system and how the legal system in a divorce might step over the law and your request because your assets are now in the hands of somebody that somebody else might be going after.
Well, think about it like this. You've got a child who's now divorced, and that ex-spouse is in control, potentially, of your financial and healthcare matters. I find that very scary because, divorces usually don't wind up well, but I do have a caveat to that, which is if people have been married for a very, very long time, then I say, okay, that makes sense. So it can be okay, but in general, I tend to shy away from it myself.
Yeah, and it's not only just in divorce. I mean, I think there might be some situations, financial situation, where a person might have a lien on their estates and their assets, the person who's in control now, and they could have the IRS coming after them or something like that. And all you have to do is have your Social Security number down, and if that person, the son-in-law, is in charge of assets for you, that could be your assets could be in jeopardy.
Yeah, well, generally, if it's in the trust, nobody else can attach those assets. However,
right. But you leaped because you just mentioned trust. And so we haven't talked about trust because trust, you're talking about a legal document.
Right.
Right, okay. So, our listeners have to hear that. What is a trust?
Right. It's what most people think of as a will, but it avoids probate. So then California...
Which is really a critical part of this discussion today.
Absolutely. And so, in California, we're probably the worst state in the country when it comes to waiting times and cost of probate. And that's why you always hear living trusts being touted. But when you get down to it, you have to name somebody to be in control of that trust. Now, of course, that's going to be you, first of all, or you and your spouse. But one day, invariably, it can't be you. You're either going to be incapacitated or you're going to pass away, and that person's going to be in control. And so you really better trust the person that you've named. And so I put it to you, Doctor, what would you say as far as who would you opt to put in control of your financial affairs if it wasn't you?
Of course, if with Robin, I would have Robin in full control. But let's say that she's incapacitated in some way as well. I would look to our children, and I always think, okay, I'd look at the character of our kids, the honesty of our kids, and with 3 daughters, that's a tough shot. Now, then I would probably go in order of age and
that's
who the
very
eldest
common.
Who the eldest is, and hope and look at their situation as well in terms of the liabilities that lie within their lifestyle and how they are.
Yeah.
And even if for the 3 girls, I would look at them and say, well, it's still a tough choice. So, in terms of looking at trust, and I would probably consider the possibility of an outside person taking a role in this,
interesting.
like a friend who might be an attorney who has special interests for me, and they'll know who I am, who might be able to say exactly where I would want my monies and my estate and my assets to go.
I would, in your situation, make a suggestion, which you may or may not like, but where you have 3 kids, what we a lot of times do is we say it takes 2 out of the 3 to act. And therefore, you kind of have a little bit of checks and balances there.
There you go.
And it's maybe ensuring that there's the right result is going to occur. And you also brought up the possibility of what we really call private professional fiduciaries or banks being trustees. And there are pros and cons to that as well. If you don't have anyone to name that you really trust, those can be great options. The downside of a private professional fiduciary or a bank, however, is that they're going to cost money, of course, and the banks charge the most. The difference between a bank and a private professional fiduciary is that a bank, if anything goes wrong, they'll be able to reimburse the estate. Private professional fiduciaries are required to keep $1 million of E&O insurance, so error and omissions insurance.
Oh, okay.
So it would be okay for an estate of $1 million or less in case something went wrong. So those are not bad issues, or bad options rather. The other thing that I get a lot, and it kind of makes sense, is parents a lot of times they say, this child is really good with financial matters or legal matters, so I want to put that child in control of the financial decisions. And then they might have a doctor, for example, as another child, and they say, I want the doctor to be in control of medical decisions. And in my opinion, that may or may not be correct. Really, when we're talking about financial decisions, I think the most critical issue is trust. You have to trust who you put in control to carry out your wishes. When it comes to healthcare decisions, you have to trust, and the person that you choose has to have the stomach to do things that may not be so comfortable, like, of course, the most critical decision is if they have to pull the plug in a situation where there's no quality of life. And so sometimes I find with my clients that they say, oh, my daughter, she'll never pull the plug. She doesn't have the heart to do it. And we've got to name somebody else. And similarly, you might have somebody that's financially savvy, but that's not really critical, because we as attorneys, we help people through the process, whether a person's incapacitated or after they pass away, and we're doing trust administration. Really, it comes down to being trustworthy, I think. Okay?
Agreed. And
Russ and I decided on our son-in-law because he has held in trust the estate of his mother who passed away. He has had
he's
a
got
little
some
experience in that,
Yeah.
and he also has a brother who suffered a stroke 6 years ago, and he's in a hospital.
Okay.
And he's taking care of his financial
He
things.
sounds like he's a really trustworthy person.
Well, that's the
And
way
experience.
yes, that's the way we felt about it.
Yeah.
And that's why we have named him in our trust.
And how long have they been married?
They have been married, let's see, since they've been married 30,
So I would say
30.
that's totally fine.
Yeah.
30 years,
30
I mean,
years.
if somebody's married for 30 years, I'm not really concerned. I'm concerned about the kids who are, let's say, they've only been married for 5 years or something like this. And statistically, we know that most divorces occur closer to the marriage. The longer you're married, the more likely it is you're going to stay married. And so I would have no problem with the decision that you made, putting him as the second successor trustee. So moving on to the second question, though, here is it's a big one, and I get this a lot. People turn to me and they ask me this question, and I'll ask you this question. To whom and how should you give your assets away to your beneficiaries? What would you say?
Whom and how? That's a hard question.
I'll give you a pass on that.
Yeah.
Gene, what do you think?
Well, I have, the three girls are all successful. They're doing their own thing. They really don't need our assets. They will move ahead in life, and whether they have it or not, it's not going to make a difference. And my thought is you come into this world with nothing and you leave this world with nothing.
Yeah.
So what I know that I want is I want to leave the world and my money is gone.
Yeah.
All my assets are distributed to the places where I know
Right.
that I feel will do the good that I have been trying to do in the world, and see if it can be continued in some small way.
Yeah.
So I would be, of course, looking at the senior center and saying, okay, senior center gets a donation, the hospital gets a donation.
Right.
And for some,
Very
their
interesting.
church or
Yeah.
where they go. I know the homeless shelter for me would get a donation. So
And-
I would
and
just
ho-
spread, like my ashes will be spread in the ocean. My anything I have in assets will be spread in this community to assure, for a little bit of time, that others who might need it will get it.
Okay,
Well-
so how would you draft that? Let's say if you were an attorney, you said you mentioned your daughters and you mentioned that you're charitably inclined. So would you leave a dollar amount maybe to charities with a balance to your daughters?
I look at my, as an accountant would, you have your list of assets, and I would just try to divide it up in a way that is seemingly equitable in the different directions that I would want to see it. So it's not going to be exact, I don't
Yeah.
think. But if, let's say, a home and a bank account, and they add those, they sell the house, add the bank account up, and put that together, and say, okay, certain amount will go here, a certain amount will go there.
Yeah.
And and depends on, there's some probably pieces of things that I have that might be donated to.
Yeah.
I have books that are kind of ancient.
Yeah.
And historic.
Yeah.
And I would want those to, and some of them already have been donated to libraries, so I would want those donated in the appropriate place.
So you bring up a lot of interesting topics. What I see a lot in trusts, because I'd say over 80% of my business is reviewing other trusts, and it's disappointing to me. But what I see a lot is that the trusts are drafted so that dollar amounts are actually given to specific organizations or people. First of all, for example, they might say, "Oh, I'm going to leave $10,000 to the senior center. I'm going to leave, $50,000 to the hospital, so on and so forth, and then maybe the remainder to my kids, and or maybe dollar amounts." And what we always do is we put it into shares, because we just don't know. Sometimes I've had 2 clients win the lottery, and their estates mushroomed, of course, and I've had clients go in the opposite direction, especially because of doctors, hospitals, and long-term care. And what they had when they created the trust is not at all what they have today. And suddenly, it's totally ambiguous when they're gone as to who should get what, because there's not enough assets to go around to make sure that people are given what the settler or the grantor intended. But even before we go there, what's really, really fascinating, I get a lot, is with married couples, of course they want to leave their estate to their spouse, right? But interestingly enough, sometimes that gets fouled up, because although it goes to the spouse, and that's what everybody wants, of course, sometimes that spouse gets remarried. And I think it's happening more and more these days. And in the remarriage situations, assets get commingled, and either on purpose or inadvertently, they may wind up with the new spouse, who then winds up leaving it to their kids, and it never goes down to the kids of the original marriage. So I think you have to be cognizant of that and drafting the trust to make sure that the distributions are going to go exactly the way you want. Also, when we're talking about kids, we don't know what's going to happen in the future. A lot of people might say, let's do that 1/3, 1/3, 1/3 to each daughter. Okay. But what happens if in the future there's a substance abuse problem, or a child is a spendthrift, or the big one, especially this is your ears should perk up on this one, Gene, is daughters with husbands. A lot of times the husbands can be very pushy and can say, why don't we just take money out and go buy a boat, or frivolously spend the money. And a lot of times we'll lock up the assets in trust, at least for a little while, because the daughters, much more so than sons, feel a lot of pressure from their husbands to spend that money. The husbands of your kids, of your daughters, a lot of times they view that money as theirs, and it's not theirs. Right. So it's a lot of interesting topics. So people come to me and they say, well, what do you think? How should I distribute my estate? And I have to ask them a lot of questions to figure out where their intent is. What's the facts and circumstances surrounding their family situation to carve out exactly the best way to set it up to carry out their wishes, is the point.
At the senior center, we commonly see seniors who have come and they're widowers, and they meet new people.
Yeah.
And one of the, I think, takeaway arguments here that our listeners are picking up is, hey, if I'm going to get married, let me make sure everything is in its right place in that marriage. Because commingling of funds and accounts and things like that will complicate an issue.
Yeah.
And so you want to know how to be able to do that prior to getting married. So that's a topic, I think, in itself. And, maybe instead of bingo over at the senior center, we'll have getting remarried and the problems related to it.
It's a similar one.
That's a good idea, I think. But we do have to take a break.
Okay, let's do that.
I'm Barbara Cochran with my co-host, Dr. Gene Dorio, and Randall Kaiden, elder law attorney, on your hometown station.